Clarence Thomas, Uncle Clarence. Let me give you a little background. And most of this comes from Alternet, the online news site, Alternet. And they put it this way: one of the most influential Republicans of the 20th century, and I might add he was also a surprise after Eisenhower appointed him, was U.S. Supreme Court Chief Justice Earl Warren. And one landmark ruling after another was handed down by the Warren Court. One of the most important was New York Times versus Sullivan in 1964, which guaranteed press freedom among the guarantees. Brown versus Board of Education in 1954, which was just a stunning ruling for equal opportunity in our education system. Now, of course, white people immediately trashed it by abandoning what were integrated neighborhoods and cities, and they just said, to hell with this. You know, that's I grew up in a pre-Brown versus Board of Education childhood. I did. And the elementary school that I went to, it was kindergarten through 8th grade. The baby boom hadn't really taken hold by then. But, you know, we had black kids and white kids. We just did. And we didn't need a Supreme Court ruling. Of course, this is in Toledo, Ohio, but it didn't require a Supreme Court ruling in order to offer equal education opportunities in Toledo. There were no colored schools. There were no white schools. I'm sure there were private academies run by the Christian fascists even back then. But it was just go to school, get your education. But I digress. Another decision that was handed down by the Warren Court was Gideon versus Wainwright. And that was, the decision came in 1963 that guaranteed criminal defendants the right to legal counsel. And 3 years later, those protections under the Gideon case got even stronger thanks to another Warren Court ruling in 1966. That was the Miranda ruling, Miranda versus Arizona. And we're all familiar with it. We've heard it on every cop show on television, in the movies. You know, it starts out, you have a right to remain silent. You have anything that you say will be held against you, may be held against you in a court of law. If you cannot afford an attorney, one will be appointed to you. That was the Miranda ruling. Miranda versus Arizona, by the way. Is it Arizona? I mean, what's wrong with that state? Oh, well. Now, as far as Uncle Clarence is concerned on the Supreme Court, he's been there for 32 years. Jesus Christ. He's made no secret of his contempt for the Warren Court. I mean, what a bastard this guy is. And he's married to just a white witch. You can change the first letter there to B if you want to. But he hates the Gideon versus Wainwright decision that a person is entitled to an attorney. The nerve of the Warren Supreme Court, right? In an opinion column that was published on MSNBC's website on March 19th, 3-4 days ago, legal blogger Jordan Rubin explains, quote, in a 2019 dissent in which he was joined by Donald Trump appointee Neil Gorsuch, Justice Thomas wrote that the justices who decided Gideon decades ago didn't attempt to square the expansive rights they recognized with the original meaning of the Constitution. Those were Uncle Clarence's words. Of course, Rubin goes on, Of course, we've seen this GOP court trample rights under the guise of originalism. And while this was only two justices calling Gideon into question, we've learned that precedent only means that what the current court's majority wants it to mean. I recently noted, he goes on, the irony of Thomas and Gorsuch wanting to revisit a landmark defamation precedent, given that doing so could hurt Fox News. But what they're trying to do, that's the end of the quote, whether it hurts Fox News or not, I don't think these bastards care, because they know what Fox News is. It's a means to an end, the end being a Christian fascist state set up in this country. Now, the landmark defamation precedent that Mr. Rubin, I'm sorry, all tongue-tied, what he's referring to is the New York Times versus Sullivan. And in that case, the Warren Court unanimously ruled that in defamation lawsuits, the defendant has to prove actual malice. And that's the thing the Dominion Voting Systems, by the way, is trying to prove in its $1.5 billion lawsuit against Fox. And thanks to the Sullivan ruling, Dominion has a huge burden of proof in that case. And Fox News' legal team is, ironically, as Mr. Rubin pointed out, using in its defense a total legal precedent that Uncle Clarence dislikes. So Fox is trying to prove that Dominion hasn't proved a damn thing where it concerns Fox's deliberate, malice aforethought attempt to destroy the election of 2020. Oh, my God. Anyway, the writer, Rubin, writes this, quote, but when it comes to further weakening the right to counsel, a majority latching onto that idea would be more than ironic. It would be tragic. That idea being that the bar should be set even higher where it concerns defamation lawsuits. Hi, Truth Seekers. Mike Malloy here. You know, the Progressive Voices Network brings you commercial-free commentary from today's leading progressive radio hosts and pundits, like me, Mike Malloy, 24 hours a day. I'm not your typical old guy from the 80s or the 90s talk radio host, and Progressive Voices is not your typical talk radio network. It's a listener-supported nonprofit with no corporate control whatsoever over our broadcast. So hosts like me, Mike Malloy, are free to rant and scream and carry on about whatever we like. We're often controversial, but we're never boring. Weeknights, 9 p.m. in the East, 6 p.m. in the West on the Progressive Voices Network. Always progressive, always on. I'm Mike Malloy. Keep it lit.